Good evening. Good evening, everyone. I'm Dr. Patrick Lewis, President and CEO of the Filson Historical Society. Thank you all so much for joining us for tonight's Theodore Sedgwick Distinguished Lecture Series, produced in partnership with our friends at the Christina Lee Brown Envirome Institute. Tonight, we are honored to be joined by the Honorable Mark Wolf. Thanks to our collaborators at the Envirome Institute and the leadership of Ambassador Sedgwick. Hand off to Dr. Ted Smith.
Awesome. Thank you so much, Dr. Lewis. So I'm Ted Smith. I'm with the University of Louisville Christina Lee Brown Envirome Institute, and we've had this joint venture here with the Filson now almost 3 years. It'll be 3 years this coming March. So good things are happening with this program, and I think it's perfectly appropriate to have Ambassador Sedgwick introduce our guest, because he is the talent pipeline for everybody that comes in here and visits us and shares their wisdom. Really grateful for this lecture series. Grateful for all you do, Todd. So come on up. How's the warm-up, Theodore? This is the real Theodore.
Well, thank you, Ted, and thank you, Patrick, and the Filson for hosting these lectures. Really appreciate this forum, which has been so productive over so many years, for great lectures, questions and answers, and so forth. Judge Wolf is a very busy man. He just, as many of you know, he recently retired from the bench. He was a federal judge in Boston, and he's been all over the news because he retired. He wrote an article, which I recommend to you, in the Atlantic magazine about why he retired. He retired because as a judge, sitting judge, he was not allowed to say much about what's going on. And as a retired judge, he's able to speak out, which he's been doing. He, as if that didn't keep him busy enough, he's also the chairman and really the conceiver of this concept of a international anti-corruption court. So he's not going to talk about that today, but he's going to talk about that if anyone has a question in the Q&A. I hope we'll have plenty of time for Q&A, because there's a lot to ask Judge Wolf. He's speaking tonight, obviously, about Justice Brandeis, but his whole career has been anti-corruption. So he worked in the Justice Department after the Watergate, and particularly for Attorney General Edward Levy. And then he went to Boston and became the head of the public corruption unit in Boston in the early 80s. And if any of you know Boston, he was a very busy guy at that time. He was so he actually had over 40 consecutive successful convictions in Boston against many people who were very high up, and including the Speaker of the House. I've had the privilege of knowing Judge Wolf for we were trying to figure today, it's been about 35 years. And we go to the same summer place, and then we've been real partners in crime ever since. When I had the honor of being nominated for ambassador, he happened to be in the same summer place, and I wanted to get to work right away. And so he swore me in. He could swear me in as a federal judge. So he swore me in on July 4th, 2010. And I was then able to, see classified documents and do all the other stuff. Anyways, then he came, when I got to Slovakia, he actually came over. There was a big problem there with corruption, specifically judicial corruption in Slovakia, where the Chief Justice was kind of a gangster. And there were these honest judges there who needed some support from outside the country, knowing that the United States was there to help. And Judge Wolf came several times to talk to these honest judges and give them the courage to keep going, which he did. And so that led him to a lot of looking at corruption to a lot of other countries, Russia, Ukraine, and so forth, Turkey. And I do want to recognize Mayor Jerry Abramson is somewhere in the audience. There he is. And I do want to recognize Dean Melanie Jacobs, the Dean of the Brandeis Law School. This lecture tonight is, thank you for coming, Dean. This lecture is about Justice Brandeis. I'm struck in looking at his talk, how much Justice Brandeis speaks to us today. And so with that, I'd like to welcome Judge Wolf.
Good evening. I resigned as a judge a month ago, but it used to be when the judge walked into the courtroom, some of you lawyers, including my college roommate, who used to be known as R.J. Strauss, lawyers, the judge comes in, says, "Good afternoon," and the lawyers with more enthusiasm they may feel really say, "Good afternoon, Your Honor." And I'm kind of missing it. Can we try this again? Can we try this again? Yeah, here, good. We'll try it again. Good evening. That's real Southern hospitality. Thank you. I'm deeply honored to give this Theodore Sedgwick Distinguished lecture on Louis D. Brandeis of Louisville. And in fact, if it weren't for Brandeis, I might not be here today. I became a judge in 1985. I was 38 years old. I worked very hard. I still do. And Brandeis, as I'll explain, has long been a personal hero of mine. And I read that Brandeis, who was a prodigious worker, once said that he learned he could do 12 months' work in 11, but not in 12. He would go to Cape Cod for a month every summer. He had a home there. And that's become my mantra. And Ambassador Sedgwick seems to be very careful to say where we don't go in the summer. This year, I've been renting on Martha's Vineyard for 50 years. And before your Louisville treasure, Christy Brown, lured him to Nantucket for most of the summer, he lived there too. And we would play tennis. That's how we know each other. I'm very grateful for that. Not just for the tennis. It's very hard for me to get a tennis game these days when he's not around. But Ambassador Sedgwick was a particularly distinguished representative of our country in Slovakia. As he said, and I can refine it a bit, Slovakia got an independent judiciary before it got an honest one, headed by a dishonest and very likely corrupt chief judge who punished the small number of honest judges. He would give them more work that they could possibly do in the period of time they were supposed to do it, and then he would hold disciplinary proceedings to eventually sanction them and try to drive them out of the judiciary. And Ambassador Sedgwick would go and watch those proceedings to let them know that the United States didn't approve of this and was watching, and to suggest there could be some kind of accountability. He also was quite dedicated to combating corruption, because he learned that in Slovakia, corruption at the highest levels was widespread, and it was a great impediment to getting the American business that Slovakia would have benefited from, and from American companies having an opportunity to do good work and make money there. He marched in LGBT parades, and over the objections of the professionals in the Foreign Service who thought it was undignified, he formed a rock band with other ambassadors, and they played all over the country. And he connected with the real people of Slovakia. There wasn't just the diplomats chatting with each other. I commend Christy Brown, not just for creating this lecture series, but more importantly, to validating the vision for Louisville through her service that was Louis Brandeis's vision, as I'll explain. And I'll say that while it would be an honor to do this at any time, it's particularly important to me to be able to do this now at this crucial time for our country and at this milestone in my own life. Brandeis has long been a hero of mine, and he was depicted in my chambers. I sat under a portrait of Brandeis. There are many other pictures of Brandeis, or a bust of Brandeis that's at the Harvard Law School. And this lecture has provided me a very timely opportunity to think deeply about why Brandeis is so important to me. Brandeis's biography is probably familiar to some of you, but not all of you. He was born here in Louisville in 1856 to German Jewish immigrants, as I'll discuss. When he was 16, his family was doing poorly financially during the Depression after the Civil War, and he studied for 3 years in Germany. He then wanted to go to the Harvard Law School, but he had no college degree, and ordinarily you would have to pass an entrance exam if you didn't have a degree. But he went and spoke to the dean, who was so impressed with his brilliance that they said, okay, you can come. He graduated first in his class and was reputed to have the highest grades in the history of the Harvard Law School up to that time, and maybe ever. When he graduated, he practiced law for 1 year in St. Louis and then returned to Boston and became the partner of a man named Sam Warren, who was part of a very old and distinguished Brahmin family. And the Jews and the Brahmins didn't mix much at that time. But Brandeis, because of his brilliance as a lawyer, his association with Warren, who had been his classmate, was welcomed into Brahmin society. He and Warren wrote a very famous law journal piece called The Right to Privacy, talked about the right to be let alone. And he became a member of the very exclusive polo club, and also, because he was such a brilliant lawyer, represented the biggest businesses in New England, the banks, the insurance companies, the railroads, shoe manufacturers, which was very big in Massachusetts at that time, for a period of time. He became a millionaire. But he also had experiences that people thought radicalized him, certainly transformed him, in part influenced by having mediated a garment workers' strike in New York, where he saw for the first time these other Jews but much lower class Jews from Eastern Europe, Central Europe, and he became the people's lawyers. He substantially devoted his work to what would now be called public interest work, which he always did for free. And I'll talk some about the Ballinger-Pinchot controversy that propelled Brandeis to become essentially the most famous lawyer in the United States, but that was in 1910. And by 1912, he was very close to President Woodrow Wilson. As I'll discuss, Brandeis was a fierce foe of bigness, big government, big business, and he helped develop, he actually conceived the Federal Trade Commission as an effort, an institution that would keep monopolies from developing because it's so hard to bust them up, as Theodore Roosevelt and others wanted to do after they existed. And also a decentralized Federal Reserve System was Brandeis's idea, to try to assure there would not be any banks that would be too big to fail. So Brandeis left Louisville when he was 16, and he never lived here again. Yet his ashes are interred at the Louisville Law School that, as you know, bears his name. And I think the reasons for that are important to understanding Brandeis, his crucial contributions to the United States, and his enduring relevance today. Louisville, particularly Brandeis's family, Brandeis's parents and extended family, forged the foundation of the exemplary public servant that he became. The extended Brandeis family left Prague in the 1850s, the late 1850s, because of restrictions placed on Jews after the liberal revolutions in Europe in 1848 were severely crushed. They were not among the tired, poor, huddled masses described by Emma Lazarus in her poem that's etched on the Statue of Liberty. Rather, the Brandeises were well-off, cultured, middle-class family. They arrived in Louisville with 2 pianos. They couldn't imagine leaving their pianos behind. But like the huddled masses, they were yearning to breathe free. Before the Civil War, Brandeis' father, Adolph Brandeis, had started a successful grain business. That business prospered greatly during the Civil War and ultimately failed due to the Depression after the war. The Brandeis family became poor, but they weren't resigned to living in poverty. Eventually, through hard work, Brandeis's brother, Alfred, and his father rebuilt a highly successful grain business. It was widely known as Brandeis and Son, and they became leaders of this community. From his father, Brandeis learned that in a small community like Louisville, intelligence, industry, and perseverance could be rewarded with a successful and a fulfilling life. As Brandeis's first biographer, Alpheus Mason, explained, from his mother stemmed a romantic strain, an insatiable desire to better conditions, and an unfaltering faith in his fellow man. Brandeis remarked about his mother, she had a sense of duty to the community, not so much by preaching, but by practice. By the time he was 18, Brandeis had developed a passionate desire to be of public service. In his youthful notebook, he wrote Francis Bacon's words, "In the theater of human life, it is only for God and angels to be spectators." The famed psychoanalyst Erik Erikson once wrote that successful men do what their mother wants them to do in the way their father wants them to do it. And Brandeis exemplified the wisdom of this insight. In the course of his career, Brandeis became renowned for his extraordinary work ethic. The story is told, and it's evidently true, that he not only worked hard himself, but he worked the young lawyers, the law clerks, he employed as a Supreme Court justice very hard. And one night, one of his law clerks worked all night on a memo that the justice wanted the next day. And Justice Brandeis, a very modest man, refused to move into the Supreme Court building. He thought it was too fancy and it wasn't appropriate. But anyway, he lived in an apartment on Connecticut, Washington, in Washington, D.C. And his law clerk, having worked all night, came with his memo, and about 5 a.m. in the morning, started to slip it under the door and could feel a hand on the other side pull it in. Brandeis also had and became famous for his passion for truth. Indeed, etched in the rotunda of the federal courthouse in Boston, where I worked, are Brandeis's words, "Justice is but truth in action." And in all of his endeavors, Brandeis made prodigious efforts to find evidence that would prove true facts. For example, in 1908, Brandeis submitted a brief to the Supreme Court that another one of his biographers said changed the course of legal history. It became the first of many of what were called Brandeis briefs. In a case called Mullen versus Oregon, his brief had hundreds of pages of statistics that demonstrated the adverse effects on women of working more than 10 hours a day in only 2 pages of legal argument. But the brief contributed greatly to persuading the Supreme Court to reverse its earlier jurisprudence that the 14th Amendment guarantee of liberty meant that women had the liberty to contract to work very long hours despite the proven harm to their health. In the Ballinger-Pinchot matter that I mentioned earlier, Brandeis's extraordinary and successful efforts to discover the facts were in 1910 demonstrated again. Gifford Pinchot was the chief forester in the President Theodore Roosevelt administration and the leading conservationist, most prominent conservationist in the United States. And he was also a good friend of Roosevelt's. And in part due to Pinchot's influence over the years, Roosevelt himself became a great conservationist, and conservation became a primary issue in his administration. In 1908, a syndicate led by J.P. Morgan tried to gain control of 5,000 acres of coal and timberland owned by the United States in Alaska that could not lawfully be sold. Richard Ballinger ran the U.S. Land Office, but resigned to work for this syndicate. In 1909, Roosevelt's successor, and actually handpicked successor, President William Howard Taft, appointed Ballinger Secretary of the Interior. And Ballinger promptly announced that the coal fields for Alaska were up for sale. There was a young man in the Interior Department named Louis Glavis. He was in his 20s. And he complained to Ballinger about this. And he was brushed off. So he went to speak to Pinchot, who was a foe, an adversary of Ballinger's. And Pinchot said, "You should go talk to President Taft yourself." I think you could do that in Washington that day. And Glavis brought substantial documentation to Taft to demonstrate that his concerns, indeed his claims of misconduct by Ballinger, were well-founded. And Taft, too, was not persuaded, but Taft requested, and he received from Ballinger, a 730-page response dated September 6th, in a 74-page report from Attorney General George Wickersham dated September 13, a week later. Taft claimed to have read both reports before authorizing Ballinger to fire Glavis on September 13. Glavis then took his report to a prominent magazine, Collier's Magazine, Collier's Weekly, and it published a scathing article about the matter titled "The Whitewashing of Ballinger, of the Morgans in charge of the Department of Interior." And it condemned the proposed sale and possible misconduct by Ballinger. The controversy this evoked was so great that a joint congressional committee was created. It had 8 Republicans, 8 members of President Taft's party, and 4 Democrats. And the Colliers was so concerned about a possible libel suit that they hired Brandeis to represent it in Glavis and Pinchot, in effect, in these congressional hearings. The chair of the committee was a Taft loyalist, and he proved to be hostile to Pinchot, hostile to Glavis, and extremely hostile to Brandeis. The hearings were vitriolic and lasted 5 months. Brandeis quickly realized that he was not going to get a fair hearing and prevail in Congress, but he realized that he might prevail in the court of public opinion. So he played to the press in both his questioning and argument in the hearings, but he met with the media every night to discuss with them what he thought the public should know from what he had done and what he was planning to do. And then scouring the newspapers and other public sources of information about the activities of Wickersham and Taft between September 6 and September 13, he realized that Wickersham could not have written the 74-page memorandum exonerating Ballinger, and Taft could not have read it before Taft authorized Ballinger to fire Glavis. Rather, Brandeis concluded that the Wickersham memo had been backdated and that Taft had lied about when he read it. The congressional committee frustrated Brandeis's efforts to get the relevant documents that would support his conclusion, but he was undeterred, and he battled fiercely in the hearings to demonstrate the cover-up because he believed that this was a demonstrated danger to American democracy. This is the President of the United States lying, which outraged him. It was outrageous at the time. The committee voted 7-5 to exonerate the Taft administration, but the public was persuaded. After the hearings ended, Ballinger resigned as Secretary of Interior. Nevertheless, Taft made the Alaska land available for sale, but the controversy prompted the Morgan Syndicate to end its efforts to buy it. And Brandeis became, in the process, the most famous lawyer in the United States. Brandeis also believed deeply in Lord Acton's axiom that power corrupts and absolute power corrupts absolutely. He decried what he called the curse of bigness. He was opposed to both big government and big business. He believed both were grave threats to personal freedom and democracy. Brandeis's opposition to bigness made him a strong advocate for federalism. He characterized the states as laboratories of democracy, where different social experiments could be done to see what best served the public interest. When his law clerks, who would be brilliant young lawyers, would regularly ask him, Justice Brandeis, I have very good opportunities to stay in Washington and also to go to New York to work on Wall Street. What should I do? And the justice would invariably say, go home, go back to where you're from. And one of his law clerks said, to Fargo, North Dakota? But I don't think the justice relented. And he also believed deeply in the importance of the separation of powers created in our Constitution. The Constitution enshrines our nation's belief that all power is in the people, that some of that power is delegated to Congress, some of that power is delegated to the president, and one of the most important roles of the courts is to limit those elected officials to hold those elected officials to the limits of the powers delegated to them by the people. His view, Brandeis's view on federalism, was expressed in a 1926 opinion in a case in which the president fired a postmaster without the consent of Congress that was required by a statute. And Brandeis wrote, "The doctrine of separation of powers was adopted by the Convention of 1787, when the Constitution was adopted, not to promote efficiency, but to preclude the exercise of arbitrary power. The purpose was not to avoid friction, but by means of the inevitable friction incident to the distribution of the governmental powers among the three departments, to save the people from autocracy. Protection of the individual, even if he's an official, from the arbitrary or capricious exercise of power was then believed, in 1787, believed to be an essential of free government." In addition, Brandeis was an ardent advocate of freedom of speech as essential to democracy. As he eloquently wrote in his opinion in 1927, in a case concerning the conviction of Anita Whitney for supporting the California Communist Labor Party, "Those who won our independence believed that the final end of the state was to make men free to develop their faculties, and that in its government, the deliberative forces should prevail over the arbitrary. They valued liberty both as an end and as a means. They believed liberty to be the secret of happiness, and courage to be the secret of liberty. They believe that freedom to think as you will and to speak as you think are means indispensable to the discovery and spread of political truth. That without free speech and assembly, discussion would be futile. That with them, discussion affords ordinarily adequate protection against the dissemination of noxious doctrines. That the greatest menace to freedom is an inert people. That public discussion is a political duty, and that this should be a fundamental principle of the American government." This statement includes and distills some of Brandeis's most fundamental beliefs. Liberty is the secret of happiness. The function of government is to allow men and women to realize their full potential. And echoing that, the words of Francis Bacon that he wrote in his notebook at age 18, Brandeis said, "The greatest threat to freedom and democracy is an inert people, people who are not actively engaged politically." All of this helps explain why Brandeis's ashes are buried at the Louisville Law School, now named for him. Essentially, why he followed his advice at the end of his life, essentially after his life, that he gave his law clerks: go home. His former law clerk and disciple, Paul Freund, doubted that Brandeis's devotion to Louisville and its university was because of a sentimental attachment to the place of his birth. Rather, Brandeis's devotion to them was a living out of his philosophy, a laboratory for his beliefs, including his strong belief that bigness is an obstacle to intelligence and industry being rewarded with success and happiness. In Louisville, Brandeis hoped to foster a democracy of engaged citizens with a sense of community. He believed that the university and its law school were important to this. Between 1924 and 29, Brandeis donated a substantial part of his huge library to the university and several $1,000s to maintain it. He told his nephew, "I assume the university to be poor in possessions. What I aim to do is to make them rich in ideals and eager in the desire to attain them. He didn't want the university to become another national institution like Harvard, but rather a school to educate citizens who would stay in this city and in this state and make them a vibrant democracy. Ultimately, there's the question, who was Louis Brandeis? And who was Louis Brandeis of Louisville? I think Freud answered it best. He wrote after Brandeis's death, "Those who knew him would speak finely and above all of his moral intensity, his spiritual greatness. His was the quality that by word could lift the heart, by a nod kindle the spirit. His moral judgments were stern and they probed deep. To him, unemployment was the most sinful waste. The persecution of helpless people brought him not only the common sense of grief, but even more strongly a sense of shame at the slowness with which the nations of the earth made protest. He was not a sentimentalist. He could not be swayed from a course he believed morally right by being told that it would involve unfortunate hardships. He realized that victories cannot be won without a struggle and that a price must be paid for every advance." Brandeis often said that we must struggle in each generation to truly possess what we've inherited. We have the great good fortune to have inherited the example of Louis D. Brandeis at a time when much of what he stood for is in danger. Contemplating his example in preparation for this lecture inspires me to strive to emulate his example, and I hope that it will encourage each of you to do that too. Thank you very much.
We do have time for questions so that everyone can hear across the room. We have two mics. I have one and Ben has one. If you wouldn't mind to raise your hand and we'll bring one to you so that we can all have a robust discussion. Who's got a question?
My question is, Justice Brandeis was considered to be a champion of civil liberties. However, he was quite silent on civil rights. Could you speak to that?
So the question, if you could hear it, if I understood it right, I talked about Brandeis as an advocate of civil liberties. What about civil rights? That's an interesting question. He came from a family of abolitionists, but while he wrote many decisions of historic importance while he was on the Supreme Court, he never wrote any of those concerning racial issues. And I haven't studied this deeply, but it's anomalous. Although I will say that I think it was more the civil liberties issues at that time than the racial issues, because refresh my recollection, he died before those issues became central. And one of the things that's always impressed me greatly about Brandeis is the way that he grew. And one of his proteges was Felix Frankfurter. I actually, for idiosyncratic reasons, inherited Frankfurter's robes. Frankfurter didn't grow the same way. When Brandeis was a lawyer, he was an ardent advocate of judicial restraint, because that's when very conservative Supreme Court was invalidating legislation. that was progressive. Brandeis had become a progressive, including, maximum hours for women. Eventually, the Supreme Court, in a case called Lochner, sort of went back on what it held with regard to women and said, well, children have a right to contract, and big businesses have the liberty to insist on people working long hours. And so they were invalidating legislation that the people wanted. But on the court, in protecting civil liberties like free speech, Brandeis, might be called activist, although I think his theory was, certainly one that I shared, is democracy should function freely and fairly, and the proper place for what might be called judicial activism is when there's some impediment to that. But I think, and I hope, I think that, well, Brown versus School Board essentially is decided based on a Brandeis brief. There's much more sociology in that decision than there is what I would consider rigorous or legal analysis. So I think, when Brandeis would have paid very careful attention to the practical effects of separate but equal to adverse effects, and would have joined that decision. That's speculation, of course, but thank you. That's a very good question.
Hi, thank you for your talk. And so my question is, right now we're experiencing a Supreme Court that seems to fall in line with someone who believes in a unitary presidency. And I wondered if you could speculate how someone like Justice Brandeis would be able to operate and what he might do in such a Supreme Court.
The decision I read, the excerpt of the decision I read in Myers, actually was in a case, expressed his view that there were limits on the president's power to fire people whose appointment required confirmation. Well, when there was legislation putting limits on the idea of a unitary executive, I think to try to figure out how to, Brandeis believed in separation of powers. So some powers in Congress and some powers in the president. You look at the tariff cases, for example. Tariffs are generally regarded as taxes. Taxes have to originate in Congress. President Trump says, well, there's an emergency. I can regulate international commerce in an emergency. So forget about Congress. And Congress has essentially abdicated its power. And the Supreme Court, the way some people assess the arguments on that recently, may rule against President Trump. The idea of a unitary executive is that these independent expert agencies that were created in the progressive era, in the around 1950, when Brandeis was advocating the creation of the Federal Trade Commission, for example, he came up with the idea there was supposed to be some protection from the president. And then there was a later case called Humphrey's Executor that said, the Supreme Court said, there were limits on the president's authority to fire people appointed with the approval of Congress, the Senate, to these independent agencies. There's a case that was argued recently where it looks like the Supreme Court will reverse that decision because Chief Justice Roberts and Justice Kavanaugh both worked in the Reagan administration and developed this idea of a unitary executive, that executive power couldn't be shared or limited. So that's one thing that I think it's pretty clear that Brandeis would have opposed that's going on today.
The parallels to today are
Let me see
extreme.
where this question is coming from. Here, stand up, please.
The parallels with today's politics are so clear. I don't know.
You get an A. You get an A for understanding my talk.
Oh, no. Everybody understands exactly
Go
what
ahead.
you're talking about here. I'm just mentioning it and I don't know where to go with it. What are your Brandeis? Take over.
Look, I'm not Louis Brandeis, but if you read my Atlantic article, you'll see that I really am trying to emulate his example. I mean, I was appointed by Ronald Reagan. But I wasn't subjected to any litmus test or anything. And I'm not a Republican. I'm not a Democrat. As I go around speaking, Ambassador Cedric mentioned, I published my article, and the next day I was in the New York Times. The next day I was on Morning Joe, and I probably did 7 other television appearances that week. Had all this 45 years of being muzzled, bottled up, and it continues. Yeah, each of these things that I discuss, I think it's fair to say, it's clear that Brandeis would have despised and as ardently as he could oppose many of the things that President Trump is doing. As I wrote in my article, as I've said to the media, we have a fundamental principle in this country of equal justice under law. And Brandeis was dedicated to that. What we have now in the abuse of the Justice Department is regular unequal justice, that the president directs the attorney general to prosecute his perceived enemies, and when professionals in the department applying established standards using established procedures think there's not a proper basis to do that, and at the same time will not allow the investigation, possible prosecution, and possible punishment of people close to him and people who are profiting him and his family tremendously. That's unequal justice. That would have disturbed Louis Brandeis greatly, and he would have tried to do something about it.
Judge, you spoke earlier about the people delegating the powers to Congress and the president. Harry Truman once said he retired to the highest office in the land, that of citizen. What would you advise citizens to do?
Well, I used to say that regularly in naturalization ceremonies. Justice Brandeis said, in this country, the highest office is citizen. And I'd say in naturalization ceremonies, your office, like my office when I held it, has duties. You have a duty to be informed. You have a duty to vote. You have a duty to work to make this country the country you hope to find and you want it to be. The key is, I think, to be politically active, not to be inert, not just to worry about it, but to see what you can do in your place with others to and to advocate and do it energetically to protect the rule of law, which is fundamental to democracy and this idea of equal justice. under law. What I read from the Whitney case, actually, Brandeis was plagiarizing a little bit. There's a book called The Greek Commonwealth written by an Oxford don named Alfred Zimmern that has a very powerful description of Pericles' funeral oration. And in Brandeis's view, he wanted Louisville. He also, I didn't talk about his Zionism, he wanted Palestine to be a recreation of Pericles' Athens, where, you know, it's Pericles who said, you know, I'm paraphrasing, because since I moved out of my chambers, I can't find all my books. I was looking for this one. But no, but Pericles in Zimmern's version said, you know, Athenians think that people who are not deeply engaged in the politics of their community are useless. And that they have a duty, just what Brandeis said, to be involved in politics. And it requires perseverance. This is anecdotal, and as I said, I'm not political, but there's a no kings movement. They're not going to change the branding. There's some benevolent kings. It should be, I think, no tyrants movement. I knew I was going to resign on November 7th, and I have two grandchildren who live in the Boston area. One of them had once been to the courthouse with me. My 5-year-old granddaughter had never been. And I was taking them with my wife to the courthouse the day of the No Kings rallies. And we drove through the center of a suburb, and there were lots of people on the sidewalks, and they had signs, and some of them were very amusing, but there was a carnival atmosphere to it. And, you know, then it happened. It was one day, and it didn't seem to have a very focused theme from what I could tell. And, you know, then in another 4 months, there'll be a carnival atmosphere. Ambassador Sedgwick knows this. I know this. You know, there are young people in the past who, there was the Velvet Revolution in Czechoslovakia. Young people went to the streets, and they went to the streets every day. And they did provoke a violent response from the government. And their parents didn't want them to go to the streets. They were afraid for them. But eventually the parents went to the street to protect their kids. And when they got tear gassed, they got radicalized too. And they had what was called the Velvet Revolution. They brought down the Soviet Union dominance of Czechoslovakia. And there are people around the world who today, in Serbia and Kenya and many other countries, who are going every day or every week, and they're not being so polite about it, and they're being persecuted by the government, but they're serious about it. So it's great to think about it. It's great to talk about it, but think about what you can do, and what you can do, you know, within your power, in your place. I was persuaded to resign. I was very skeptical. A number of people I respect, starting last February, urged me to resign. They thought I would have some special status by virtue of what I'd done in my career, in the coincidence that I was appointed by Ronald Reagan to be heard. I was deeply skeptical, but I don't often confess error, but at least on that, they were right. For a month, people wanted to hear from me, and I still have a lot of invitations to speak and to join with others. But, you know, figure out how you can be active, what you can do together. And as Brandeis said, you know, there can be hardships if you get into the struggle, but advances, or in our case, I would say protecting the rule of law in our democracy requires getting into the struggle. We're proud to say, I've often said, you know, the United States has had the longest continuous democracy in the history of the world. But that should teach us every other one failed. And it would be hubris, it would be arrogance to think that our democracy couldn't fail. And that people, I'm sorry, I'm going on too long, but I was asked that first week after I resigned on the PBS NewsHour, was I concerned about being harmed? And I said, I realized that there was some risk of that in the current environment, because you know, there are threats of violence against judges regularly, and it's for obvious reasons. You'd have to be obtuse not to see that there's some risk. But what I said was, and I didn't know I was going to say this, I hadn't thought of it before. I said, yeah, I realize there's some risk, but this country has been very good to my family and me. My grandmother crossed Russia as a teenaged orphan in a covered wagon. My father got into Harvard during the Great Depression in the 1930s and couldn't afford to go. Yet my family was able to progress sufficiently that I could get an excellent education and get the most meaningful opportunities for fulfilling public service. And I would like to try to assure that my grandchildren and everybody else's grandchildren in this country, and in fact around the world, has the same opportunities for life, liberty, and the pursuit of happiness that I had. That's why I do it.
We'll close with one final question.
Thank you. Do you, or perhaps if you interpret Justice Brandeis, have an opinion about the United Dynamics, is that the right one? Decision.
I'm sorry, which decision?
Citizens United.
Oh,
yeah.
Citizens United. He would have absolutely abhorred that decision, which was in itself a feat of judicial activism. What's judicial activism? It's invalidating legislation enacted by the people's representatives. And sometimes that's necessary to promote democracy. However, he abhorred bigness. And the theory of Citizens United is corporations, which didn't exist at the time of the Constitution. The present Supreme Court says they're originalists. And you know, what did the founders think? Well, they wouldn't have thought that corporations had freedom of speech, because I think there were no corporations in 1787. But he abhorred bigness. And he did believe in free speech, but there's a nuance that I didn't build in, but now you've teased it out. Brandeis believed, with Oliver Wendell Holmes, it's a classic view of the First Amendment, which I have shared, but now I have to rethink, that it was in what I quoted from Whitney, that the best antidote to bad speech is better speech, that better speech will prevail in the marketplace of ideas. But he believed that there had to be an opportunity to respond. And what we have now is, well, any of us can say what we want, can express our political opinions, but our views, if you try to persuade somebody to vote for the candidate you prefer, your voice is going to be utterly drowned out by the millionaires and billionaires who are financing campaigns. You know, believing in the curse of bigness, I believe that despite his dedication to free speech, he would have felt that this is creating an unconstitutionally unequal playing field, and he would have not agreed with Citizens United. There's a case that's going to come from the state of Maine, and I haven't got as deeply into this as I intend to, that's going to be argued pretty soon, because actually it's not Citizens United that opened the spigot the most, I'm told, but another case that was just decided, which was only decided by the District of Columbia Circuit. It's not even a Supreme Court case, but there's a case that coming to the Supreme Court that could put limits on contributions or remove the existing limits, which are feeble. And we should watch this state of Maine case and how the Supreme Court comes out on that. Hasn't been argued yet, but that's another a lot of very good questions.
Well, thank you all for the robust discussion. Another round of applause for the judge.